Yes. Now you can tell us about yourself. We want to know who you are, what vision you have that you want to bring to the position of the High Court if you are successful, and other skills, knowledge, and values that you think you have that you will bring to this position. You have 5 minutes to tell us all that.
Okay, thank you, my lady. I will start by saying that my name is Adelaide Amimo Akong'a. I am an advocate of the High Court of Kenya, having been admitted on the 8th of May 2008. Since admission, I have worked predominantly in the law firms and primarily in the litigation department. So with what I have experienced in my area of expertise, I would first of all say that I have appeared before various tribunals, before magistrates' courts in various countries, the High Court, and very few matters before the Court of Appeal. I have had the opportunity to handle a wide plethora of clientele, and of course with the clientele also comes with the kind of work that we do, primarily in commercial, that is relevant to this position, would be commercial, civil, and family-related matters. So, of course, the first thing I'll be bringing in when I come in as a judge will be the competence level, that I have I've worked with diverse issues, and I'm able to, understand and I'm able to analyze different aspects of the law. On a second perspective, I also come with integrity. Throughout my career, I have not engaged in what would be called unbecoming conduct. So I believe that is an essential component, that as a judge, you need to come out as one who has integrity, because the end users are, of course, are the populace, are the public, and of course, I also would need to instill confidence. So integrity, of course, would be a key component. I think I would leave it, and of course, maybe I would add one more thing Sorry, I'm a bit nervous.
Relax, and take some water.
Okay.
Yes.
Okay, throughout my career, I consider myself to be very efficient. And when I talk about efficiency, in terms of meeting strict deadlines, because with litigation, you have to be constantly on your feet. You have to also have the ability to think on your feet. So those are some of the skills I'll be bringing in when I come in as a judge. Efficiency. And also, I also like employing the tool of case management. In fact, in the firm, I'm actually leading in terms of case compliance. Most of my matters are compliant and they're ready for hearing, or most of them have hearings. And that is a key component, because when you're ready in terms of case compliance, that would mean at any time you're called upon to proceed with the matter, then you're actually ready. Your witnesses are ready, as the advocate you're ready, unless there are extenuating factors that will hinder me from actually progressing the matter. I think I'll leave it at that,
yes.
My lady.
So what vision do you have for the judiciary?
The vision that I have is in terms of selfless service, because you do realize, and of course through the START document, that it is a people-centered document. So it will be more primarily about service delivery to the people, and with a tinge of excellence, with a tinge of efficiency. And when I talk about efficiency and I talk about excellence, it's also because we all know that the primary duty of a judge is in terms of hearing cases and, of course, doing judgments and rulings, and where necessary, giving directions. So I hope to be articulate in that front, that there will be quick dispensation of, there will be quick conducting of hearings, and also that in terms of delivery of judgments, it will be timely, my lady.
Very well. The next set of questions will be read by Justice Murima.
Thank you so much, Honorable Chief Justice and Counsel. Once again, welcome. And we will have a very short discussion. You intend to join the High Court, and I wish you the very best.
Thank you, my lord.
I wish you the very best. Now, when you come into this High Court, you realize that it is a court which is operating within a certain legal framework. Can you think of 3, 4, 5 statutes which will be interacting with in the course of your work as a High Court judge?
I think the first one would be the Civil Procedure Act and the Civil Procedure Rules. by virtue of the fact that you're handling a lot of civil matters, and by extension, of course, the commercial matters, because if you're looking for Order 40 and whatnot. The second one, as a judge, would be, of course, in the way you conduct yourself as a judge. That will be the Judicial Service Act, Code of Ethics Act, because it also will tell you how to manage the court in terms of impartiality, in terms of integrity, independence, etc. I think I would also have the High Court, I think you call it the Organizational and Administration Act, which gives a hierarchy of the courts. The fourth one would be, if you're handling criminal matters, Criminal Procedure Code, of course the Penal Code, the Evidence Act, by extension, yes.
Okay, good. Have you handled election petitions?
I have never, my lord.
You're aware that the country is gearing towards elections next year?
Yes, my lord, yes.
Okay. And let us take it that you have been appointed into the office, and the Honorable Chief Justice has again appointed you as an election court. So you have no excuse from handling that election petition. I want us to briefly look at elections. Many a times, elections are challenged through petitions, isn't it?
Yes, yes, my lord.
Through petitions. And could you be in a position to know the provision of an election law, a certain election law, on which these petitions, almost all the petitions, are hinged on? There is a specific provision in one of the election laws whereby all the petitions, from the presidential to the ones for MCAs, they all hinge on that provision.
I know the Guiding Act is the Election Act. I may not be really conversant with the specific section, but it will be the Elections Act.
Yes.
And perhaps to add on that is under Article 140, when you're dealing with the presidential elections, it is very articulate on how you go about it. Then when you're talking about the governors and you're talking about the MCAs, you would have to be guided by the Elections Act.
Okay, so I mean, I take it that even in the course of your preparations, you did not find time at least to familiarize yourself with the presidential petitions like the 2017, the 2012, the 2022, just to have an overview of elections.
I had a look at Article 140 in terms of presidential elections and the timelines within which, for example, if you are aggrieved, you have 7 days within which to file the petition.
Did you?
Sorry, 7 days.
Yes, it's okay.
Yes.
Did you go through the 2017, 2012, 2022 petitions?
No, for the cases I didn't go through that. I only looked at the Article 140 and the Election Act.
Okay. So I take it further that you have not been interacted with Section 83 of the Elections Act.
Maybe if you remind me, I have done a lot of reading, my lord.
Okay. This is how it's couched. No election shall be declared to be void by reason of non-compliance with any written law relating to that election if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in the written law, or that the non-compliance did not affect the result of the election. Did you come across that?
I think I only concentrated on specific areas.
Okay.
I may wish perhaps I may wish to refresh at a later stage.
Now, in your legal practice, where do you mainly practice from?
Here in Nairobi.
You are in Nairobi?
Yes.
Okay. And you said your areas of interest in practice are?
Relevant to this suit, to this application would be civil, commercial, and family-related matters. But other than that, also have appeared before the specialized court, that is in the ELC court and the Employment and Labor Relations court.
Okay.
Yes, and also various tribunals.
Okay. Then let's look at family law, just an aspect of consent, the spousal consent.
Yes.
What is spousal consent generally? What is it?
My understanding it is that, of course, when you're talking about a spouse, I'm assuming it's a relationship between a husband and a wife, and they have property. And that would mean that, for example, even if the property is solely in the name of the husband, and the husband wants to take out a loan facility with the bank, he has to sign a document called a spousal consent, and that is actually necessary. Otherwise, that transaction will become void.
Okay. Now, are there instances in a marriage when spouses are dealing with properties,
yes,
where the issue of spousal consent will not be necessary?
I think maybe in a polygamous setup, because, for example...
How?
Sorry?
How in the polygamous setup? I'm interested to know.
In a polygamous setup, for example, if a man has 3 wives,
yes,
and you notice that perhaps this property, the first wife acquired the property, of course, by the time the second wife was coming in, we use that example, by the time the second wife was coming in, the first wife and the husband had already acquired this property. So when you're talking about spousal consent, it will not just be strictly between the husband and the first wife, because the second wife came after, after they had already acquired this property. That would be my understanding.
And what about if the husband and the first wife acquired the property before the incoming of the second and the third, but the property was developed during the presence of the second and the third?
Okay, that would portend a very interesting scenario. I think also because if you were to look at in terms of the Matrimonial Properties Act, where we are looking at contribution and of course whatever developments we made, I think it will be necessary also to consult them, because I'm assuming that at the time at which the second and the third wife are also making developments, that the first wife is aware, that everyone is aware, and they're actually on the same page. So I think, yes, it will be necessary for all of them to acquire the spousal consent.
Okay,
yes.
That's right. Thank you so much, and I wish you the very best.
Thank you, Judge.
Good afternoon.
Good afternoon, Honorable Attorney General.
Have you practiced criminal law a bit?
Just a bit, 1 or 2 matters. But it's very limited, though. Very
limited?
Yes.
What, in your view, is the difference between extradition and surrender of fugitive offenders?
I think when you're talking about extradition, it is, for example, where an individual has committed a crime in, say, country X. They are not within the confines of Kenya, but they have committed a crime in, say, country X. And so there will be a request from country X when they know that this criminal is in the country. They will, through the AG, through your office, seek to intercept him and arrest him. So, of course, you'll be guided by the extradition statutes so that this person is taken through the system and taken back to country X for perhaps to go through the criminal system.
Both of them deal with would-be offenders or people who are supposed to serve sentence, and both of them deal with people who are in foreign countries?
Yes.
So what is the main difference between the two procedures?
I think for me the difference would be surrender is they're already in the country and the government decides to surrender, as the word suggests. And then extradition it's more formal, where the request has to come through the AG. And then, of course, there's the criminal process that where you're inquiring as to whether this person truly should be extradited, and then the process continues and they're taken back to the country requesting.
Assuming you succeed to become a judge of the High Court of Kenya, and a matter is brought before you, wherein a fugitive is supposed to be surrendered to a foreign country, but they invoke the jurisdiction of the High Court appellate jurisdiction on the grounds that that extradition was not properly anchored, or that, they appeal against the extradition. What are the 3 bars to extradition amongst many?
I think for me you would have to check, for example, though I'm not very conversant, but I think you'd have to check, for instance, has this person committed a crime? That evidence has to be tendered. If there's a conviction, if perhaps there's a judgment to that effect, it has to be brought to the attention of the court. Honestly, I'm not so very conversant.
This person is before you?
Yes.
What are the 3 grounds that would be invoked to conclude that this extradition is not proper? Or what are the 3 bars to extradition that if they exist, then the person will not be extradited? The lower court has already decided that the person should be extradited, what would be the 3 grounds of appeal to the High Court?
I think, first of all, would be the kind of request.
I'm not saying there are 3, there are many, but
Yes.
I just want you to give me 3.
I think the first one would be the process. If the process was, whether the process was properly initiated. As I've said, you have to go through the AG. The requesting country has to go through the AG. And then, of course, there's the formalities that go pursuant to that. Then 2, truly, have you committed that crime? Is there evidence to that effect? I think I will leave it at 2.
Okay. Thank you.
Thank you, Honorable Chief Justice. Adelaide, I appreciate what you're telling us about your area of practice, but you know, if you're successful and you join the court, you may actually find yourself being thrown into the criminal division.
Yes, my lady, I agree.
Yeah. So it's important that you're an all-rounder. 1 or 2 questions. We talk about direct evidence, indirect evidence, hearsay evidence, and I want to believe that you understand what all those mean.
Yes, my lady.
All right. Hearsay evidence in terms of admissibility in a criminal trial, can you tell us what its value is or what its place is in a criminal trial?
For hearsay evidence, I think if my understanding is that it's not direct, first of all. It is an evidence that you've had. You're not even too sure whether what you've had is right or wrong. So when you're talking about its place in the criminal trial, for me, I think it will not have any probative value, because it is something you had. You've not seen it. You don't have direct interaction with that evidence.
No, but supposing it is you who had, why are you saying you don't have direct interaction?
Oh, sorry, I was talking now in the instance of a third party. Sorry.
Okay.
Sorry, yes.
So, okay. So what are you saying about it, that it doesn't have probative value?
Maybe I can qualify it by saying if it's by a third party, somebody reports to me that I had,
yes,
that it might be 50-50. I may not look at the probability value would be a bit lower. But if it was, I directly had it, and if it was in an environment.
So if you are conducting a trial, you
Yes.
are conducting a murder trial, and a witness testifies, and he or she gives hearsay evidence, how are you going to consider that evidence in determining that charge?
It will still border. Okay. First of all, I think you look at the circumstances under which you had the evidence.
I can simplify it further. Is it
Okay.
admissible?
In my case, I don't think it's admissible.
You know, I want you to tell me not things that you think, but things that you know.
Yes, my lady. It is not admissible because if you had, for example, if you're talking about a murder case, I had somebody being killed. Did you witness? Because I think you're looking at the weight of that kind of evidence.
All right. You are near there in terms of saying that it is not admissible, although you haven't quite told us that. So I want to give you a scenario. There is a person who is at the point of death.
Yes.
And he has been stabbed. And he says, God forbid, I was stabbed by Adelaide. Yeah?
Yes.
So in terms of what we've talked about here as evidence, the person died. And the witness is saying, I heard the deceased say, I was stabbed by Adelaide. What is the value of that evidence in that trial?
I think now that will carry some weight, because if the victim, or rather the deceased, was able to identify, and by calling out that name, that I think that will hold a higher threshold. I would take it in. But then again, not only on its own, but also other circumstances, because you'd have to check up, for example, if after all you've mentioned my name, for example, in terms of when the investigations have been done, was I actually at the scene of crime? Can I be connected to that scene of crime? So I think on its own, no, but when you put them all together,
so if
yes.
the only evidence that is there in that criminal trial is that evidence that the deceased person mentioned the person who stabbed him, is that sufficient for purposes of a conviction?
My answer still will be no.
I think you'd need to check on that. And do you know what these, what we are talking about in terms of how are they classified? How is it classified? Is the evidence of a dying person who subsequently passes on, having said who stabbed him or who caused the injury that eventually led to his death? Have you heard of a dying declaration?
Yes.
Yes. After this, please check whether the evidence, the dying declaration is admissible and whether it is okay. You've said it's admissible, whether it is sufficient for purposes of a conviction without any other evidence.
Okay.
Thank you.
Thank you, my lady.
Thank you, Chair. Good afternoon once more.
Good afternoon, Commissioner.
I just want to revisit the area you are engaging with Judge Sichale before I ask you the questions that I had, because I'm not sure I understood you correctly. In respect to hearsay, we have hearsay evidence and we have direct evidence.
Yes.
Please distinguish the two.
I think going by the discussion we've had with Lady Justice, I think even the dying declaration can be considered direct evidence.
No, just explain what is direct evidence, what is hearsay, because I just, at some point when you are giving examples as you're explaining,
Yes.
the distinction was getting lost to me. That's why I'm asking.
Direct is when you have, for example, if in a murder case, say there's somebody who actually witnessed the evidence, that I would easily call direct evidence, because you witnessed and you saw.
As in, if you saw.
Yes.
When it comes to hearing, what is direct evidence?
When it comes to, sorry?
Hearing.
Hearing.
Mm-hmm.
That can also be a form of direct evidence, because if you had, that's why I was talking about, have to look at the circumstances. What was the proximity? Maybe there was a lot of noise. Was there silence? Were you the only one in that room that you could hear? What was the tone? What was the volume of the dying declaration, for example?
What is direct evidence when it comes to evidence that can be heard, as opposed to hearsay? That's what I'm looking for. Distinguishing the two.
Maybe I'd wish to refresh.
Okay.
Yes.
So maybe we can discuss what I had to ask you. I wanted to engage you on. I see you've basically been practicing
yes,
the entire period
yes,
since you are admitted. Eh?
Yes.
So what distinguishes you? Because we are looking for distinguished legal practitioners in this exercise. What distinguishes you?
First things first, if you were to look at my CV, I have attached jurisprudence. Mm-hmm. So one is the creation of jurisprudence. Two, of course, is I'm conversant with what happens in court, because I'm in court practically every day, except, mm-hmm. of course, maybe on Fridays. So if you're looking at the learning curve, it will be a bit shorter, because I know where to find the law. I know how to go about it. In terms of also analyzing, in terms of case law, I'm able to do research. Also, of course, guided by stare decisis, I'm able to, practically engage with the case laws and be able to fit them in the particular cases that I'm handling. And of course, number 4 would be the element of efficiency, because as I said earlier on, in litigation, you have to be fast-paced. You have to have the ability to think on your feet, because any small sluggishness will actually cost your client's case.
Okay, let's talk about efficiency. In the last review, in our SOJA report 24-25,
yes,
there was an overall reduction of backlog in the judiciary by 31%.
Yes.
What was the High Court backlog reduction?
I think 54%.
I think you need to check that. What about the adjournment rate at the High Court?
The adjournment rate was very high.
How high?
I can't remember the exact percentage, but I do remember it was very high.
Which level of court was leading in the adjournment rate?
I think it was the High Court. Sorry? It was the High Court. It was the High Court.
Not quite. It was actually the Magistrates' Court. You'll need to confirm that. Now, the question I wanted to ask, if you're successful and you do join the High Court, so how will you go about addressing this situation? I've given you two parameters.
Okay.
The status of backlog in the High Court, they were only able to reduce 8%, and the rate of adjournment.
I think when I looked at your report, there were internal. Okay, let me just go direct to the question to answering the question. I think my experience in the commercial court is that, for example, is that there are too many applications. You'd find that even in one matter alone, you end up handling like even up to 10. I have had that experience where you're handling even up to 10 applications. So if we can reduce that time, instead of arguing applications, ensure that parties are compliant, and that we put in your. I've seen what the High Court nowadays does. You have a trial bundle, and you go for hearing directly. That is actually one way. If of course,
so you do away with the interlocutory applications.
Yeah, do away with the intellectual applications.
Okay,
yes, and
one
then
strategy.
that's
Any
one
other?
strategy, and then the second one would be you, of course, the multi-door approach, where you encourage parties to discuss matters out of court. It can be on their own volition, or they can, of course, approach the mediation. There's the court annexed mediation. There's also reconciliation, and there's what you call the AJS, the alternative dispute way of resolving issues. Yes.
Exploring multi-door. Any other?
Multi-door approach. And then 3, I think, again, we would have to go back to case management, because that is where the secret lies.
You know, all these are part of case management.
Yes.
So I'm just asking what strategies you'll put in place.
Another strategy would be if you can also narrow down the issues, because I've noticed also in commercial matters, you'll find that there are issues where parties are able to agree. If you're able to agree, that will also be one way of diffusing the tension in the High Court.
Okay, thank you, and I wish you well.
Thank you.
Good afternoon once again, Council.
Good afternoon, Commissioner.
Do you need some water break, or you're good to
I'm okay, thank you.
Glad to hear that. So I've reviewed your 5 sample writings. They are submissions from Civil, Commercial, and ELC Division. But I've taken note that out of the 5 that you submitted, 3 are unsigned and undated. Maybe you can explain to us
I am
why.
sorry, Commissioner. I think it was an omission on my part. I should have given signed copies.
Oh, okay. Because you can't tell whether they actually come from you, but we've taken note of your explanation. However, they demonstrate clear issue identification, strong reasoning, and effective application of law to facts. They are coherent, legally sound, well structured with proper use of precedent. The tone is measured, and conclusions are clear and persuasive. So congratulations in
Thank you.
a good job. So my second question is that abortion touches both on the right to life and right to health. In such a case, if a case of this nature were to come before a High Court, can the court issue structural interdicts to give practical effect to the intersecting rights?
Maybe rephrase the question. Sorry.
Abortion touches on both right to life and right to health.
Yes.
Can the court, High Court, that is, issue structural interdicts to give practical effect to these intersecting rights? Maybe you can explain your answer.
If we look at Article 26, of course, we all know when you can invoke abortion. It's very limited. In terms of structural interdicts, I think that yes, it would be possible, perhaps only on a supervisory front, because if it's affecting the health of the mother, and of course this is a lady or a woman who is entitled, of course, to the right to health, then yes, the court would actually be able to provide.
So explain it. I want you to explain. So your response is yes, but how do you ensure you give those orders at the same time, understanding the constitutional basics and the limits of such an order? So what orders would you want to issue? A woman comes and says, I have a right to abort. The doctors have refused. So what would be the structural interdicts look like when you say yes, you can grant such orders?
I think I'd put it this way. When you look at the Article 26 of the Constitution, it only provides for abortion in very limited circumstances, and that is only when the life of the mother is in danger. So when you're saying that as a woman you just decide that you want to abort, that would not be right, because again you'd have to look at the penal code, if I'm not wrong, because when you're saying you want to abort for other reasons other than what is contained in the article, it is a criminal offense. I think you are liable to go to prison if you're found guilty for 2 years. So I think I would rephrase the question and say it will be limited to what the Constitution provides. Because even in that article, it says, as guided by any other written law. And of course, as we all know, I don't think I've ever come across laws that talk about abortion. So it will be very limited. If you are saving the life of the mother, well and good. But anything else, because you just feel like you want to take away the life of the baby, that will not be allowed. It will be strictly within the confines of the Constitution.
So other than the Constitution and, as you mentioned, the Penal Code, what other thing will guide you in coming up with a determination?
I think what you're talking about, statutory interdicts.
Okay, I'll leave it at that. Thank you.
Thank you. I'd like to test you a little bit on case law from the Supreme Court. In the last few years, the Supreme Court has developed jurisprudence around the best interests of the child.
Yes. Mm-hmm.
Are you aware of these matters? And if you can elucidate.
I think, if I recall, one is about a Muslim child born out of wedlock, whether they have a right to inherit. That is the one I can quickly think of.
Can you think of anyone, any case relating to the custody of children?
The one that I have read, I think the parents were busy fighting, and there was a parental responsibility agreement. By the time the matter was concluded, the child had reached the age of 18.
So this parental, are you aware of the facts of that case?
I can remember, yes.
Yes, so...
I've read so many Supreme Court matters. I think it was more to do with, there was a custody fight, because one parent was in the UK, if I can remember correctly, mm-hmm. and one of them was in the country. So there was a fight between who the two should have custody of the child. It's only that it's unfortunate that by the time they were coming, when the matter was being determined before the Supreme Court, the child had attained 18 years of age, and now the court said, since the child is of age, they had the option of choosing whether to go to the UK or remain in Kenya.
Yes.
Yes.
The Supreme Court also talked about parental responsibility in that matter. Yes. What did they state?
It stated that both parents have an obligation to take care of the children. That not when you're talking about both parents, none of them has superseding rights over the other. Okay. They will have an equal status.
What will the court consider when deciding to allocate custody to a child? To a parent.
To a parent.
Yes.
You would, of course, have to look at the economic factor. Mm-hmm. You'd find that probably one parent is okay, one parent is perhaps deficient.
What else?
You also have to look at the wishes of the child.
The wishes?
There are children who prefer to stay with one parent as opposed to the other.
Okay.
Yes.
Yes. What else?
In terms of, I've talked about economics. Please allow me to remember.
There are maybe 6 or 7 parameters we gave. So you've given me 2. Okay.
I think the best interest of the child.
Yes, certainly.
Yes, yes.
All right. What about in criminal law? What matters are you aware of that the Supreme Court has made a finding on in the area of criminal law?
Muratetu case?
Apart from Muratetu?
I think there's one to do with the minimum mandatory sentences under the Sexual Offences Act.
Still Muratetu, or is there another matter?
I think I'm conversant with those 2, the ones I can recall.
Okay. So thank you. Thank you very much.
Thank you, Judge. Thank you.
Thank you, Honorable Chair, and welcome again, Wakili.
Thank you, Commissioner.
Now, if you became aware of corruption allegations in your court, could you take us the steps that you will take to minimize such incidences and restore public confidence?
Corruption from the members of the bar, from...
In your court, from both?
From both. I think, of course, we'll have a zero tolerance. Of course, as we all know, the court has a zero tolerance policy on corruption. So you have to make it very clear to the court users, and that would mean the advocates and, of course, by extension, the clients or litigants in this instance, that the court does not entertain corruptive practices, and that too, of course, in the manner in which you carry out yourself, because you do remember, even as judges, sometimes perhaps you may also, in one way or another, interact with the populace or with the public. You also have to avoid instances whereby you are caught up in a situation whereby you will be handed over what you call bahashas, and yeah, I think basically that.
Have you interfaced or encountered any corruption
In the judiciary?
Yeah.
No, so far, no.
Okay. All right. Thank you, Chair.
Thank you, Honorable CJ. Council, I have a few questions for you. In your many years of working experience, what has been your biggest professional challenge and how did you overcome it?
The biggest challenge for me, of course, is the workload, because I work in a firm that has a lot of work, because as I mentioned earlier on, we have a lot of commercial work and civil work. So that has been challenging, because it's a question of how do you manage your time, and at the same time, how do you ensure that you're also fit to do the work, and at the same time also prefer your services well to your clients. Of course, the second one is, of course, I think by virtue, this I experienced in my formative years of practice, is that sometimes when you are cross-examining male litigants, some of them will become very abrasive. They will not understand why you as a woman were actually asking them questions. So with time, that also have to put your foot down and make them understand that it's just part of your job, and that you have to carry on with what you're doing. So that those to me would be the two challenging things. And then, of course, three would be sometimes we face a lot of backlash from our clients because of delay in judgments, and sometimes, of course, because of the hearings. Some of them take too much, especially in the commercial division, in terms of adjournments, in terms of delay in judgments, because the business community have this tendency of saying, if we filed our paperwork and we have our evidence in court, why is it that the courts are a bit slow and a bit sluggish in giving us, judgments, knowing all too well that they have good cases? So that those are the challenges I have experienced.
The work of a judge is very demanding.
Yes.
How are you going to ensure that you have work-life balance?
First of all, it will be to prioritize, because once you're able to, for example, you prioritize in terms of the kind of work that you have. You notice you have applications, and you have, of course, complex matters that will come by your desk. If you can expend more time, see, like, for example, if you're having an application to amend a plaint, I don't see why you should take too much time in deciding a matter on such a matter, and yet you can utilize that time to deal with the complex matters. And of course, how you would diffuse the heavy workload is it is necessary also to ensure that you rest. Like I myself, working in a high volatile environment, I like taking offs. Like every month, once or twice, you'll find me away from my desk. And that has a way of diffusing, so that once I come back to my desk, I actually fresh to handle whatever matters are on my desk. So that would be one way of doing it. Balancing, prioritizing, and of course, taking the necessary offs. It's very important.
Okay. What is the place of artificial intelligence in the judiciary?
Not to write judgments, of course. I think you can use it as a tool, a very good tool in terms of case management. For example, like what you generate with your soldier reports, you can be able to tell how many matters you filed in a year, how many matters are pending judgments, how many matters are on appeal. That can be used as a very good tool to that effect. You can also use it as a tool for research, though you also have to be very careful, because sometimes when you're doing your research and you're actually looking for the actual case in the Kenya law, you'll find that they're talking about two different things. So you also have to guard against that. Also, in terms of typing of proceedings, that can also be a very good tool.
Okay.
Yes, but in terms of writing judgments, no.
Okay.
Yes.
Finally, do you believe CSR is important?
Yes, it is.
Why?
Because it is an arm where you actually giving hope back to society. Because if you look at the kind of activities that have been done through CSR, for example, you're helping in building of schools or you're paying school fees, it's actually restoring hope back to the populace. Because when you're talking about the judiciary, it's not all about making laws and protecting the constitution. There's also a side of the judiciary, the soft side of the judiciary, whereby you are now conversant with the daily tribulations of the public and be able to make a difference the best way you can.
Okay.
Yes.
On a personal level, are you involved in any community service?
Yes, on my own. I do it on my own, on a personal level, as Adelaide. I do it in two fronts. As Adelaide, where I support single ladies whom I have identified in church who are not able to, for example, take care of say, a simple basic need like food. I always provide for them. I have a specific budget for them each and every month, so that it really helps, because if you have somebody who is not at work and they have all these other concerns to take care of, if you at least take care of one concern as they think about the rest, it usually, lessens the burden. And then of course, when you're talking about the church, also the church also has the community based, where once in a while, like last year in December, there was a community service element to it, whereby we went to, I think it was in Muthaiga, where we were giving food to those who were not able to, take care of themselves during that season, especially during the festive season.
Okay.
Yes.
Thank you, and I wish you well.
Thank you, Commissioner.
So now we come back to you so that you can tell us from your own analysis of what is happening in the world. In which country or continent do you feel or think that the rule of law is threatened?
I think in the Islamic countries, where there's a lot of terrorism.
Terrorism in the...
Sorry?
Terrorism in the Arab countries.
Yes, my lady.
That is what you think is the greatest threat to the rule of law.
Yes.
Any other?
I think, of course, what happened, like the Venezuelan president.
What happened there?
Where the president was taken away by the American president. That was not right. That was a sitting president.
What was the breach of the rule of law there?
Surely, if it's a sitting president, there are mechanisms to... actually, a sitting president is actually immune. That is what I'm basically saying.
Okay.
Yes.
So, in your view, there was a breach of sovereignty?
Yes.
Very well. So this brings us to the end of the interview. But before we release you, there is something from Judge Shale.
Just one clarification. You're talking about terrorism in the Muslim world. Are they freedom fighters or are they terrorists?
They're terrorists, my lady.
Please be very careful. Don't stereotype people.
Yes, my lady. I'm sorry.
Thank you.
Okay.
I stand guided, my lady. Thank you.
And don't generalize.
Yes, my lady.
Yes, because it's not even all the Islamic countries have terrorists.
Yes, my lady. I stand corrected.
And it's good to identify terrorism as a crime by whoever is perpetuating. Okay, so we give you also an opportunity for you to engage us, because we have been engaging you all this time.
I think for me, I'll take it as a moment of appreciation. This would be the second time I'm appearing before the interviewing panel. I do not take it for granted. Thank you for granting me a second opportunity. And my prayer for you is that once you retire, I know it is an arduous task, getting 20 out of 100. I would pray that the God that I serve, I am a Christian, that He will grant you wisdom in coming up with the 20 that will now be ready to serve the populace. My lady, thank you.
Thank you for those good wishes. On behalf of the commissioners, I also wish you all the best. And we will get in touch with you when we complete the exercise.
Thank you, my lady.
Have a nice day. You are released.
Thank you. Thank you very much.
Yes.